Hello everyone, welcome to the new laws, the new forms, the new cases, and the new year. My name's Bryan Zuetel. I'm a real estate attorney. Been a real estate attorney for about 15 years, specializing in just about anything that ever touches real estate. Non-disclosure, business cases, landlord-tenant, HOA disputes, disputes during the transaction, disputes after the transaction, and also trying to structure your transactions so that they don't end up in court. I do both litigation and transactional work, and enjoy both sides of it, trying to keep you out of the court, and when you're in the court, trying to help you win or help you defend yourself or help you get out of court. So we're going to talk today about the forms, we're going to talk about the laws, and we're going to talk about some cases that have happened, and then there'll be a time at the end for Q&A. So I have to give you this attorney-like disclaimer, okay? I'm an attorney. I'm not your attorney. I'm happy to be your attorney, but we got to talk before then. We have to have a retainer in place. So everything that I'm saying has to do with a general nature, has to do with what is going on out there, but not with your specific case, transaction, or you specifically. New year, new forms, new laws, and new cases. So with new forms, obviously we had the RPA rewrite a few years ago, and they're still rewriting the RPA. Not wholesale rewriting it, but they're tweaking and fixing a lot of things that they're finding as they go along. And this year, December, was no different of 2 months ago, that they did tweak and change and modify a few things. So we're going to talk about those. And then also with the wholesale change of the RPA, you also found that people became confused with some of the language that they put in. So we'll talk about some of the confusing language, how it's working out, some of the new forms even that they're developing because of the language in the RPA, and hopefully it'll be helpful for you. We're going to talk about 5 forms. There was 10 main forms that was released apparently a few months ago. We're going to talk about 5 of them, okay? And that's going to include the RPA. That's going to include the RPA, the Tenancy Occupancy Property Addendum, the Solar Advisory and Questionnaire, the Non-Contingent Offer Advisory, and the Buyer Representation and Broker Compensation Agreement. So we'll start first with the RPA. We're going to hit on a few sections within the RPA. I'm going to generally describe to you what they say or what they do. I would encourage you to go read them yourself and understand exactly what they're doing or trying to do within the RPA. So RPA 3G3 says, seller agrees to pay the obligation of buyer to compensate buyer's broker under a separate agreement, CAR, SPBB attached. Seller's broker's offer, if any, to compensate buyer's broker is unaffected unless otherwise agreed. So this is in the table that they put in there. And there's just a little box in there that you can check to invoke this part of the new RPA. And this has caused a lot of confusion because people are asking, wait a sec, seller, you're telling me the seller is now going to pay the buyer's broker. Now, if you've been doing real estate for a while, you understand, right? You get a listing agreement. In the listing agreement, there's an agreement from seller to pay listing broker X%. Remember, there's no set percentage. I'm using only an example. This is not an antitrust violation, okay? But let's assume it's 5%, okay? So seller agrees to pay listing broker 5%. And then further on in the listing agreement, it says what? It says listing broker agrees to offer via the MLS to a buyer broker, a cooperating broker, X%. Usually 2.5%, again, not set by law, but usually 2.5% if you're being offered 5%. Again, subject to negotiation and however you arrange it with your clients. So now we have agreement number 2 from listing broker to buyer broker, or seller broker to buyer broker, okay? Now, within the relationship between the buyer broker and the buyer, a lot of times you don't necessarily have a signed agreement, right? How many people are using a buyer broker agreement out there? 1, 2, okay. Just a handful of you. It's a pretty rare thing, and we're going to talk about perhaps why it might become industry standard or why it might become mandatory in a little bit. But it's a rare thing. So what this is trying to capture as an optional box is this. I'm going to give you an example so we can kind of flesh this out. This requires an existing buyer-broker agreement. So don't check this box if you don't have a buyer-broker agreement. You're kind of stepping in some hot water there if you're checking the box saying, I have a buyer-broker agreement, but you don't actually have the buyer-broker agreement. Because this references the SPBB form, which references an existing BRBC form. So don't check that box unless you actually have that buyer rep agreement in place. Because this is only going to apply when the amount agreed to by the cooperating broker, the buyer broker, exceeds the compensation in the listing agreement, or in the listing, in the MLS listing. All right, let me give you an example to kind of help us with this. So, example, BRBC agreement, the buyer representation, the broker representation buyer compensation agreement says that buyer agrees to pay his broker 3%. Okay? Pretty standard, right? They can agree to that. That's subject to their own negotiations. They agree to 3%. You start making offers, you start showing properties, you start making offers, and you get an offer accepted. But the unfortunate is that the MLS listing that you made the offer on is only offering 2.5%. So what do? Now, most of the time, you would say, I'm happy with 2.5%. I'm not going to try to pursue the 3% against my buyer. It would be kind of a rarity, right, if you went for an arbitration or a litigation against your buyer for that remaining 0.5%. But here's the question. Can the buyer ask the seller to compensate the buyer's broker for the remaining 0.5%? Again, this is something that's kind of in flux right now. I've only heard of one person actually doing this successfully. It was not well received at first. It took a bit of discussion and negotiations over various things. So it's a possibility that's out there. Can the buyer do this though? Yes. Now the buyer is not negotiating. The buyer is not negotiating a number of things. Let's get to this. So remember, this is only optional. Again, I got to stress this. Only optional what we're talking about, but it's caused a lot of confusion. Now, there's been a suggestion out there that this would violate Article 16 of the Code of Ethics, which says that the buyer-broker cannot use the buyer's offer to negotiate or modify their commission. Okay? So the reason that this is different, though, is because the buyer is the one negotiating for the buyer-broker commission. So it's not the buyer broker per se that's negotiating this difference, this 0.5% in my example. It is the buyer who's negotiating. So there's not a violation of Article 16 there. It's also been suggested maybe MLS Model Rule 7.12 could be implicated here, could be violated here. Well, Model Rule 7.12 only requires an offer of compensation be put into the listing. So there's no minimum. I mean, technically there's no minimum. I guess you could put $1 in the MLS listing. I remember the days of the $100 many years ago, but it can be done. So these are not violative of Code of Ethics or MLS rules. Again, this is only optional. But then it was suggested, it was thrown out there, I think rightfully so, maybe this could be abused. Buyer and the broker write up a buyer representation agreement after making the offer or concurrently with it. They say buyer will pay 5% to the broker, and so you try to go make this up with the seller. Again, these are negotiation points, and it's also subject to the implied covenant of good faith and fair dealing. Okay, every contract in California has what's called an implied covenant of good faith and fair dealing, which means you will deal fairly with the other parties, and you covenant to deal in good faith and fairly. So, yeah, I guess it's subject to abuse. It'll have to be, again, fleshed out. We'll kind of see how this operates, but for now, it's there, and that's kind of how it's supposed to work. So, does the buyer have to produce the BRBC before the seller might negotiate to pay the additional commission? It doesn't exactly say that. So, again, Imagine you got a buyer broker saying, hey, buyer owes me 5%, and the seller says, I'm calling you on that, produce your BRBC. And they say, no, I'm not producing it for you, it's not your contract. Well, again, I think this is kind of running into some of the good faith elements, and again, it's negotiable. So seller could say, I'm not paying your commission, okay? I'm accepting this offer, I'm countering back, we're not paying any commission other than what I've agreed to pay the listing broker already, and the listing broker has offered in the MLS. That's 3G3. And I mentioned briefly the buyer-broker agreement. We'll get to that in a little bit as a new form and go over that as well. Next, the 3L2, the appraisal differences. I don't know if you experienced this, during the extreme height. You had those folks that were coming in, right, offering $1 million, but saying I'll waive the appraisal contingency if it comes up to $950. Okay. Now there's language in here because I got to tell you, I had a few transactions during that time, and I saw all kinds of language being written by agents as to how they would structure this, and some of it was bad, and some of it was messy, and some of it was causing their clients to step into it. So CAR has helpfully put into 3L2 of the RPA now how you do the appraisal difference in an offer versus the appraisal price. Okay, it says appraisal contingency is based upon the appraised value at a minimum of the purchase price, that's our standard one, and then there's a blank there. And again, this is in the paragraph 3 box that you would fill this in. So you can fill in the price there. So let's look at an example. Again, I said purchase price of $1 million, but a minimum appraisal of $950,000. So buyer is committing himself or herself to make up the extra difference of $50,000 for the purchase price of $1 million should the property only appraise for $950,000. So if it appraises for $950,000, the buyer can't exercise the appraisal contingency because it's appraised at the $950,000, and the buyer has committed themselves with this offer, with this accepted contract of making up that extra $50,000 in the total scheme of this purchase here. So I don't know how many people are doing these kind of appraisal, versus purchase price offers anymore. It might become important again in a few years, but it's there for you. 9B2. I called this the what comes with the home. Kind of known as the fixtures law, but the what comes with the home. So this is a little small. I'm going to read this for you, but this is 9B2. This is everything that comes. So you can tell your buyer if they ask what comes with the home. Existing electrical, mechanical, lighting, plumbing, heating fixtures, ceiling fans, fireplace inserts, gas logs, grates, solar power systems, built-in appliances, appliances for which special openings or encasements have been made, window and door screens, awnings, shutters, window coverings, which includes blinds, curtains, drapery, shutters, or any other material that cover any portion of the window, and any associated hardware and rods. And I'm going to stop there because apparently there was an issue going around with hardware and rods being taken. Sellers taking the curtains, leaving the rods. So CAR put this in there to deal with that issue. So you got to leave the rods now, okay? Attached floor coverings, television antennas, satellite dishes, air coolers, conditioners, pool spa equipment, including the pool cleaner, heater, net, covers, garage door openers, remote controls, mailbox, in-ground landscaping, water features and fountains, water softeners, water purifiers, light bulbs. Light bulbs. Tell your seller they can't take the light bulbs, okay? Including smart bulbs and all items specified as included in paragraph 3P if currently existing at the time of acceptance. That's all that definitely comes with the home unless it's countered out. And there have been cases, and I've dealt with cases involving some of these things here. So there's reasons these are here. Now, the next question is in 3P1, what might come with the home? And remember, this is where you can check the box for the various things. You're used to the appliances, right? You check the box for the appliances. Well, there's more than just the appliances. The things you can check the box for are stoves, ovens, stove-oven combo, video doorbell. I've had a case with a video doorbell before being taken. Above ground pool and spa. Yep, you can't dismantle the pool and take it with you. You got to leave it there if the box is checked. Security camera equipment, bathroom mirrors. I've dealt with multiple cases where they took the bathroom mirrors. Refrigerator, security system alarm, wine refrigerator, separate video doorbell and camera equipment, electric car charging systems and stations. That's going to become more important, right, as we go along, as we have more and more electric car charging stations in there. Make sure you're checking that box if your buyer wants that charging station. Washer, dryer, smart home control devices, potted trees and shrubs. I got to stop here. You know, attorneys are not cheap. And I don't know why, but there was a case where they were fighting over taking the potted plants. And I had to ask them, like, how much were those potted plants that you're so upset about? It's like $100 or $200. I was like, oh my goodness. So check the box if your buyer wants the potted plants, okay? And then it should be no big deal. Dishwasher, wall-mounted brackets for video or audio equipment, and microwaves. So that's everything that might come with the home. And make sure to check that box in 3P1 if your buyer wants anything, or to counter it back out if your seller wants to keep his potted plants. Next, RPA 11M, the solar advisory. Obviously becoming more and more important as more and more people are getting solar panels, solar power system. There's a requirement now that the seller provide all known information about the solar panels or the solar system. And the RPA now advises use the solar form, SOLAR form, solar advisory and questionnaire. Sometimes it's difficult. Sometimes your sellers may not have all the information, but I would suggest that they do their best to fill out that solar form. We'll look at that in just a sec. That will be helpful to advise the buyer on the solar systems. RPA 3M3, the tenant occupant in possession. This now says seller shall disclose to buyer if occupied by tenants or persons other than the seller, and attach a TOPA form in a counteroffer if not part of buyer's offer. So a seller in the standard RPA is saying either the unit is vacant, there's tenants in there, or I, seller, will remove all the people that are in this home who are under 18. Okay. What do you do about the brother-in-law who sleeps on the couch? What do you do about the spouse who isn't on title? Some of these questions have come up, and so the idea with the new form is that the seller will represent to the buyer, here's all the people that live in the home who are over 18, and I, seller, will agree to have all these people out of the home. I think it says 3 days before close of escrow for tenants, and I, seller, agree to vacate the home at the time of close of escrow or however you negotiate it post-close, okay? But this is important because there are more and more, say, boomerang children, boomerang kids living at home. What do you do if the 21-year-old is back at home? He says, I didn't agree to sell the home. I didn't agree to leave. I don't know who you are. Yes, you're probably in the right, Mr. Buyer, but you don't want to deal with the unlawful detainer eviction court. You don't want to deal with pursuing seller for your damages. You don't want to deal with the 21-year-old boomerang kid, okay? So I would almost exclusively use the TOPA form, the TOPA form, unless you see that the property is clearly vacant. You have, as the parties are trying to navigate this transaction, you have much more upside to using the TOPA than downside. So use that TOPA form. The TOPA form is an addendum to the RPA between the buyer and seller. It says seller must deliver the property vacant. It says vacant 5 days prior to COE. I think there's a provision in there if the seller's living there, you're not kicking them out of their home 5 days before the COE. But it's useful for the non-seller over 18 occupants of the property. And we dealt with that. Term and condition of the seller. What if the occupant resists, refuses to leave? What are your options? Well, they're not great options. You're at the closing table, you're getting ready to sign final loan docs, and you find out the 21-year-old is living there. Cancel the transaction, you have that option under this addendum. Extend escrow, that's another option so that the parents can remove the child. Or take subject to getting the person out. That's not a great option either. It's not a great system if you have this situation, but the TOPA gives you the best options for dealing with this situation. Solar advisory and questionnaire, again, not required, but the seller is required to disclose everything the seller knows about the solar panels in the solar system. So why not use the solar form that CAR developed? Highly recommended if there are solar panels or a solar system on the property. It includes boxes for the seller to disclose info on leasing, ownership arrangement, and a whole host of other things that go into a solar system. Next, the non-contingent offer advisory. How many people, is anyone seeing non-contingent offers anymore? I don't think so. I mean, I've heard about some up in the Bay Area still, but it's still pretty rare. But CAR has a form for you now. The form is here. It probably won't be useful to the next up market, bull market in the real estate industry, but it's here. And what the non-contingent form does is it advises the buyer of the risk associated with making a non-contingent offer. You never want to be without the paper that says, I, agent, I, broker, advise my buyer this is a risky offer when you don't have contingencies. There's a lot of things that could go wrong. Your money, your initial deposit, your subsequent deposit might be at risk. But with this form, I'm not saying it's foolproof, but with this form you can say once again, I tried to warn them that non-contingent offers are risky and have inherent downsides to them. Maybe in the end they make their own decision. In the end, each buyer is their own person and make a decision, but this way you've advised them one more time of the issues with making non-contingent offers. The buyer representation and broker compensation agreement, the BRBC form. This form replaces the prior three. If you remember, there were three different buyer-broker agreements that you could use. This form is replacing them. It defaults to a non-exclusive representation where the broker only gets compensation if it's the property that they show to the buyer and the buyer buys it. It has certain boxes you can check in it to modify it to make it into an exclusive representation where if the buyer buys any property during this time period, then perhaps you could be compensated. You'll specify the number of days and the compensation in there. And then I mentioned this. This form's not mandatory. I saw only 2 hands when I asked if people are using it. The way some things are trending in real estate, this form might become mandatory or at least industry standard pretty soon here. So I'd encourage you to familiarize yourself with this and to start familiarizing your buyers with this as well, because we'll hear later on about some of the other things, but it's a good idea to start getting these in place as a buyer agent. Does anybody disclose to their buyer directly how much compensation, what commission they're going to be getting from a transaction? Sometimes, okay. Yeah. Once in a while? If they ask, okay. It's a rarity, right? I mean, sometimes they'll see it. I've had maybe one person ask before, but there's a new form, ABCD form, that is referenced in the BRBC form. And in the ABCD form, you would actually be disclosing the amount of compensation or the amount of commission that you'll be getting from, I believe it's broken down by property, from each property that you'll be showing them, okay? The idea with this, again, is kind of trending towards some of the national lawsuits and some of the federal investigation and lawsuits, and how is organized real estate structured. So it's something to think about, and it might, again, become an industry standard thing. Is it on this form? Yes. Okay. So the question is, if you're using this form, are you expecting the buyer to pay you? The way the BRBC form works is the buyer says, I will pay you, broker, 2.5%, but any amount that you get from the listing broker in the MLS will be covered or will be credited against my payment to you of 2.5%.
Thank you for that.
Okay, so if the listing broker puts in the MLS 2.5% and the buyer broker agree to 2.5%, then it's a wash, because then the listing broker, or really the seller, is paying to the buyer broker the amount of 2.5%. Okay, I think one of the reasons behind this form, it has to do in part with DOJ investigation and the idea that it's kind of secret how much commission you're getting or how much compensation you're getting, or it might have to do with the idea that you bad buyer brokers are picking only the highest commission properties to show to your buyers, and you're dismissing those that are the 1% or the 1.5%. I'm guessing here, I'm just surmising, but this form is here, and it might become, like I said, mandatory or industry standard pretty soon.
Can I ask you one last question on that?
Yeah, so the question, what if your buyer loves the $100 compensation commission listing, right? If your buyer loves that, you do have a fiduciary duty to your buyer. When you have a buyer-broker agreement, you have fiduciary duty to them. So you have a duty to protect them, to act in their best interest, to act as a fiduciary to them. I would say you probably have an obligation to show them that property, and then to explain to them what it would be like, or what the amounts would be, a buyer paying you 2.5% minus $100. And that might be a hard conversation to have, but that is your duty as a fiduciary and as just an agent to explain the ramifications of showing the property, making an offer, following through with the consummation of that transaction. All right, let's talk new laws. Anyone, take a guess. How many bills did Governor Newsom sign last year? Too many. Oh. 20, all right. You're playing the Price is Right low number, right? Yeah. $1. Yeah, $1. He signed about 1,000 bills last year into law. 997 to be exact. Now, thankfully, there's only approximately 30 laws or so that affect real estate, and we're not even going to talk about all 30. But there's a lot of laws in our state. We live in California. There's a lot to be aware of. We live in Orange County. We probably don't see it too much, but in other parts of the state, even the county to the north of us, there are still significant COVID restrictions in place. County and City of LA have once again, County of LA has once again extended the eviction moratorium on evictions up until the end of March. There are some other very serious restrictions in place related to COVID, rentals, back rent, a number of things. So be aware of those if you're doing any kind of property management or anything having to do with rentals in the County of LA and the City of LA. There's also kind of unknown as to whether Governor Newsom, as he starts to kind of roll back some of the COVID emergency orders, whether some of them are still in place. In particular, it's a little unknown if the anti-rent gouging law is still in place. There's two sides to it. Both have good points. It's not very clear. But if you have anyone who's looking to raise rent, it's safest, even if they are exempt from the 2020 Tenant Protection Act, it is still safest to only raise it by 10%. There's a new law, a first look program is what it's called, AB 2170, put into Civil Code 2924P. And what this does is it allows, where you have a large foreclosure company, and there's a special definition of this, a certain number of transactions or foreclosures they have to have per year. But when you have a large foreclosure company, there's restrictions on the purchase of those foreclosed properties. And there's a priority that's given to owner-occupant buyers, nonprofits, and public entities for the first 30 days. So they are allowed, again, the name of the law, first look. They're allowed a first look at the foreclosed properties and to make offers on those properties. And there's another requirement: the bank must respond, and I put that in quotes, must respond in writing to offers. What that means kind of remains to be seen. We'll see. But this is a new law that will significantly alter the way that foreclosures and REOs are practiced in this state. What else? Oh, I forgot to change the heading there. But another law. This is another law about renting a home in your HOA community. Can you rent a room in your house in an HOA community where it's HOA controlled?
Yes.
Yes? No? Before this law, you weren't too sure. You had some HOAs saying, nope, we're not allowing you to rent a room in your home. Remember, Sacramento's trying to deal with the housing crisis and trying to come up with creative ways to do this. So now you can rent a room in your home where you have an HOA, even if the HOA says no renting rooms in your home. There are limitations on this, okay? So this is the lodger law. When you rent a room in your home, it's called a lodger as opposed to a tenant. So a lodger law. Now, this does not count toward the 25% HOA restriction for total rental. So HOAs can put in place a 25% total rental cap on their HOA community. Well, Sacramento says that renting a room in your home does not count toward that 25% for total rentals in an HOA restricted community. And to answer the question, the HOA can still prohibit short-term rentals defined as 30 days or less. So this does not affect the Airbnbs. So 31 days in Laguna to rent a room might be doable. All right, this next one is not a law. Apparently the DRE commissioner said something a few months ago that kind of concerned people, and there was some back and forth as to whether agents could sit in an open house of another brokerage. And so this has been clarified recently. There's no prohibition on open houses, on sitting at another broker, another agent's open house. But there is this requirement that you can only do licensed work for the broker who you hold your agent license under. So how that works out is a little ambiguous right now if you're sitting at another open house. So it was suggested that if you're sitting at another company's open house, be careful how you represent yourself to visitors. You don't tell them I'm sitting for this real estate company here. You tell them who you are, who your broker is or your brokerage is, and you tell them you're opening up this home, you're sitting in this home, because you're not the listing agent. That's what you got to make clear. You are not the listing agent, and there's an implication when you're sitting at an open house. The general public kind of thinks you're the listing agent. So it is highly suggested that you clarify that for anyone who might come in. Anyone doing high-end rental or high-end purchase or sale in Los Angeles or Santa Monica? Anyone want to do it? $10 million? Yeah? Yeah? Okay, all right, good.
And then you hear this.
And then you hear this, yes. No, well, as long as you don't own the property, you might be okay. LA measure, this is Los Angeles measure ULA and Santa Monica measure GS, which just passed. They were passed ostensibly to deal with housing affordability and homeless issues, and this is a significant tax, as you'll see, on sales of properties in these cities. We'll see how it does with LA and Santa Monica homeless.
So it's not passed yet? Sorry.
It is passed. It is passed. Definitely passed. So we're going to look at it real quick. LA measure ULA becomes effective April 1. So it's passed, but it becomes effective in a couple months. It applies to transfers of any real property in the city of LA. Residential, commercial, vacant land, any real property is affected by measure ULA. It's a tax imposed on any sale that's over $5 million, and it's imposed on the full sale amount regardless of gain or loss, regardless of assumed debt. So just X, whatever X the sales price is, this tax is imposed on that. If it's over $5 million, it's a 4% tax on $5 to $10 million, a 5.5% tax on $10 million or greater. So just doing rough numbers, it's about an extra $200,000 tax on a $5 million sale and an extra $550,000 tax on a $10.1 million sale, all in addition to City of LA, County of LA documentary transfer taxes, which are also up there. Total rates of about 4.5% to 6% tax. So what do you do? Well, first, who's exempt? So the exemptions that are built into the law are nonprofit entities, community land trusts, limited equity housing cooperatives, certain bankruptcy and partnership transactions, and certain gifts. Okay, but your average run-of-the-mill purchase and sale transaction is going to be affected by this. So there's currently pending litigation by Howard Jarvis Taxpayers Association and the Apartment Association of Greater Los Angeles challenging this tax. Now, I do a fair amount of work in LA courts as well. I can tell you it's going to take a while to work its way through the court system, because that court system is backlogged pretty bad. So I don't see even the pending litigation having much effect. Certainly not before the law takes effect in a couple months, and it might take a few years to work its way through the system. So could you convert your ownership to a cooperative? Not usually. Those are usually two different interests. The cooperative has a separate legal definition to it that probably wouldn't apply here. So what's the solution, though? I mean, that's what you're looking for, is what's the solution to this, okay? So if you, again, $5 million and over, what do you do? One option and all of these are novel. None of these have been tried out yet. These are just being thrown around on kind of attorney forums. What do we do to get around this tax? One idea, break up the property into separate parcels with different ownership and sell each parcel for less than $5 million. How that works with a Beverly Hills mansion, well, that wouldn't be LA, but how that works with Hancock Park mansion, I don't know. But maybe if you had a vacant land that was downtown LA, you could subdivide it and sell it for less than $5 million. Keep the sales price for the real property under $5 million. So if it's a $7 million property, you sell the furniture and the grand piano and everything else for $2.1 million. And the real property is then $4.9 million. This has some appeal to it, as long as the furniture is really worth arguably what's being paid for it. So maybe they need to throw in a little bit to sweeten the deal. I don't know, but that's an option. Sell the land. Another idea, I don't think this one has much legs to it, but another idea is you sell the land that's under you in one transaction, you sell the structure that's on the land in another. That has some issues as well, but hey, it's creative. The last one that's kind of interesting, and I think has some good value to it, is if you structure the property ownership in a tenancy in common plan with each TIC interest under the threshold. So perhaps if you had a $10 million property and you broke it up into 25% tenant in common interest and sold those off to 4 different people for $2.5 million each, that might be an option. That's a lot of work. That takes some significant tenant in common agreement and a few deeds to get there, but that's another option that's being thrown out. The last option, sell your property before April 1.
We like that one.
Yeah, you like that one, right? Not the best option if your house is not ready, but that's when it takes effect. There's also a ballot initiative that just got enough signatures that's going to be on the 2024 ballot for City of LA, and it would invalidate the Los Angeles measure, and it would also try to, I take it back. I think that this got on the California ballot. I think it's on the California ballot for 2024. And the idea behind this is to try to make all future special tax increases subject to a 2/3 vote rather than a simple majority. Measure ULA got 57% of the vote, but not the 2/3 that would be required under this law. So there's kind of this retroactivity built into this ballot initiative that would be, useful to invalidate.
I have a question.
Yeah, so that's a good question. So could the buyer and seller negotiate who pays for it based upon maybe tax write-off or other tax implications? Certainly they could negotiate it. My understanding of ULA, though, is that it's a requirement by the transferor, so the seller, who has to pay it to City of LA. So it might work against you if the buyer increases his price to try to get it to seller to pay the tax. But that is subject to negotiation. So that's another option as well. Wouldn't you love to have that buyer who's willing to pay your tax? All right, new cases. I'm going to deal with two or three cases real quick, and then we will be done and have time for questions. Whitlach v. Premier Valley 2022 case challenging the independent contractor status and the way that real estate's been done for many years. Plaintiff James Whitlach was a realtor with the Century 21 office, I believe it was in Central Valley. He tried to characterize himself as an employee of the brokerage. He said he was owed a minimum wage, he was owed meal breaks, he was owed overtime, and he alleged a bunch of labor code violations. And so he sued Century 21 under what's called the Private Attorney General Act. Coincidentally, the Private Attorney General Act provides for attorney fees. So who do you think was interested in bringing this case? It was his attorney, because of the attorney fees that he could potentially recover. Thankfully, the trial court dismissed the case, said, nope, you are an independent contractor, you're not an employee. And the Court of Appeal recently upheld this dismissal. The case has been appealed to the California Supreme Court. My prediction is I don't think they're going to take it, because I think the Court of Appeal did a really good job, in their opinion, of outlining the difference between an independent contractor and an employee in real estate. And this is where it becomes important for any brokers that have any agents under them, any brokers or office managers who are assisting a broker. This is what the Court of Appeals said. They looked at Business and Professions Code 10032, and they said a real estate licensee is an independent contractor if these three conditions are satisfied. The individual has a real estate license. So I hope you don't have a real estate agent without a license at your brokerage, okay? The individual has a real estate license. The individual is paid for services directly related to sales or other output rather than the number of hours worked, so i.e. commissions. So the realtor must be paid commissions. And this is the important one to consider, the individual signed a written independent contractor agreement that stated you will not be an employee, you will be an independent contractor. So I think the big moral of the story for this, for any brokers or office managers, is double check all of your independent contractor agreements. Make sure you have those in place for all of the agents, and make sure they're active and up to date, particularly with some of the recent tweaks that CAR has made to some of the to the independent contractor agreement. So make sure you're keeping those up and you have all of those in your files. Funny enough, speaking of the ICA, the independent contractor agreement, the plaintiff in this case challenged the CAR ICA, the independent contractor agreement, claiming it was unconscionable and unenforceable, and the court rejected all those arguments. They said, no, this is a good form. This is a good agreement. This is very clearly outlined, so it's a good form to use. So we'll see. We'll see what happens when it goes to the California Supreme Court when they make their decision.
Oh, they haven't decided?
No, they haven't decided. They have, I think, till the end of this month, if I remember right, to make a decision whether they'll take it. It's very unlikely. Again, the Court of Appeal did a good job on that case. You probably heard about the Nar versus United States, or United States versus Nar case, the Department of Justice that was investigating Nar. They reached a settlement agreement under the prior administration that had a number of conditions in it. And then there was a changeover in the administration. There was an attempt by the new Department of Justice to revisit some of the agreements in the prior settlement agreement. They started backing out. They said, well, we need to investigate more of these things. And NAR said, no. An agreement's an agreement. We already settled on this. We already agreed to this. We're going to enforce this settlement agreement. 2-3 weeks ago, let's see, who was it? It was the DC District Court, United States District Court for DC, said No. DOJ had an agreement in place. DOJ agreed to this settlement agreement with NAR, and you're going to be made to live with this agreement despite the change in the presidential administration. NAR was obviously happy with that. NAR put out a description which said that NAR had updated its guidelines to reinforce greater transparency and disclosure of compensation offered to buyer's agents, to ensure that listings aren't excluded from search results based on the amount of compensation offered to buyer agents, and to reinforce that local MLS market participants do not represent brokerage services as free. So what does this mean for you? What does this mean for the disclosure of the compensation for the buyer agent? This is what I was referencing earlier. It might be coming. You might be needing to make a disclosure to your buyers of the amount of compensation you're going to get based upon this settlement agreement. I don't know if you saw this change in the MLS. I guess for years you could sort by commission percentage, and now that's been taken away. So you cannot sort a listing by a commission percentage. That was part of this settlement. And buyer's agents, you can no longer say that you are offering free service. You cannot say that your service is free. I'm sure you can think of other creative ways to say that, but you just can't say that it's a free service, because the thought behind it, part of what the DOJ was worried about, is that the seller is paying the listing broker, who's paying the buyer broker. So the buyer broker is being compensated by somebody. It is not free. Was kind of their reasoning behind that. So if you're a buyer agent, buyer broker, don't call your services free. Like every good case, this is going to be appealed. If it hasn't been appealed already, it's probably going to be appealed to the DC Circuit Court of Appeals, and it will work its way through there. And I'm sure one side will be unhappy, and it'll probably go to the Supreme Court. We'll see if they take it. Is that a hand? The question is, who was this driven by? And the political answer is that it was driven by the Department of Justice. I'm sure we could all say, and we're not supposed to say, so I'm not going to say, but you could have your thoughts as to maybe who was behind this. But at the end of the day, Department of Justice was the one doing the investigation. They were the ones who decided there's something to look at here. And they've done this. They've done this, 30 years or so ago, there was a big investigation of the title company, and they restructured the whole title world through a DOJ investigation. So the DOJ does this, and I wouldn't say it's that unusual. It happens. But stay tuned. It's not over yet, and it's probably going to be a number of years before we have super clarity on that. What else? Last, just kind of vaguely, there's plenty of ongoing federal and state litigation you might hear about. Louisiana, Missouri, there's class actions pending around the country. These can have impact on you. So be aware of these. And there's some that are challenging the clear cooperation policy. There's some that are challenging the commission, the whole commission structure of organized real estate. There's some that are challenging the very idea of having an MLS and how that creates anti-competition. So there's lots going on, but these are the big ones for now. That's my contact info. All right, everyone, thank you.